This just in, an urgent court application by Numsa and Sacca in the Labour Court has been dismissed. The court says it's not within its jurisdiction to consider the lawlessness of the actions of the SAA business rescue practitioners in this case. Heidi Jaka is following the story for us. She joins us now live. So Heidi, this coming in a short while ago. First, let's start with what the unions were actually asking the court to do.
Yes, indeed. So Numsa and Sacca headed to the Labour Court on an urgent basis to ask the Labour Court to declare the fact that the SAA business rescue practitioners, together with the Department of Public Enterprises, are acting unlawfully by not willing to pay workers 8 months a salary instead of 3. They're rather willing to pay them 3 months instead of 8 months. So Sacca and Numsa were trying to force the SAA business rescue practitioners to say that there was never an agreement to only pay workers 3 months, and there was always an agreement to pay them back 8 months. And this dates back all the way from March, Shahan. But the two unions have lost that application. And this is because the Labour Court finds that it is not within its jurisdiction to perhaps rule on whether or not the SAA business rescue practitioners are acting the way they should as SAA business rescue practitioners. But also what's interesting here is that the court has also ruled that in light of fairness, the workers should at least get paid 3 months salary, and perhaps the 8 months issue should be looked at a later stage. But Shahan, this matter has been going on for a very long time with regards to Numsa and Sacca trying to fight for more money for their workers. We do know that the airline is still in business rescue 14 months later, and the workers are saying that the Department of Public Enterprises, together with the SA business rescue practitioners, have not been fair in their conduct with regards to dealing with how much they actually get paid. Workers were under the impression they would be getting paid 8 months, and then later on they were told they would only get 3 months, and that's it. When we spoke to the Department of Public Enterprises last week, we were told that it's important for them to only pay workers 3 months because the rest of the post-commencement funding, or the funding that was given to the departments and the business rescue practitioners, needs to be used to restructure the airline and get the airline back in the air. So on that basis, they're only going to be getting 3 months, and this ruling does not work in favour of the unions or the workers that are affiliated to Numsa and Sacca.
Yeah, and of course these unions were hoping that the court would intervene because they were getting no joy from government on this matter. Have they released any statements just yet?
Yes, and it's an important point you touch on there, Shahan, because from what Numsa and Sacca have indicated, they have reached out time and time again to the SAA business rescue practitioners, and it seems as though there seems to be a disconnect between the Department of Public Enterprises and the SAA business rescue practitioners. If you'll recall, about 2 or 3 months ago, when the money was finally given to the SAA business rescue practitioners, the business rescue practitioners came out saying that the conditions that have been set by the shareholder, the departments, contravene the Act. And this is very concerning because the money should be used to pay for workers, and this is being used for something else. But Numsa and Sacca have told us that they are not in a position to comment at this stage, and they will be studying the judgments and make a decision moving forward. One must understand that workers are in a very difficult position, with some workers even opting to take 3 months' salary because they just have nothing else, and this has been a very long road for them.